cost and interest, and I don't remember what the actual amount was. Ms. Mast then became subject, I think, to a garnishment after Mr. Rognus registered this foreign judgment in Michigan default. But there are a couple problems. One, more than 21 days have passed since the entry of the default. And two, the default was in Indiana. And what is going on here is just a ministerial registering of this judgment from another state so they can try to collect it here. Ms. Mast, you filed a motion. I think we waived the fees. You attached a bunch of stuff about the car, and this is the same thing we always get, the car conked out. This happened 8 years ago, and the judgment entered in Indiana. And Mr. Rognus, you filed a brief, which I appreciate. You wish to speak to this further?
Yes, Your Honor. Originally, the promissory note or the contract was when she lived in Indiana. When they did file suit on this, they had to utilize what in Indiana they call an alias summons, and here in Michigan we call alternate service. And they perfected service in Indiana pursuant to Trial Rule 4.1. So I don't necessarily know that there is any basis to make a judgment. And as I did indicate in our brief, I guess it's not ideal, but she's only accumulating interest at the Indiana statutory rate of 8% instead of the Michigan statutory rate at 13%. Certainly, if she wants to talk about setting up a wage assignment or something like that, our standard operating procedure is once they're paid off, we'll do a step to set aside the judgment, dismiss the case, help them out substantially with their credit history as well.
Ms. Mast, what triggered this? This judgment entered way back in 2017. And what normally happens is things just lay dormant until they actually start to try to collect. So what caused you to file this motion to set it aside?
I was never aware of it. They apparently served me the papers at an address I hadn't lived at for years. So I didn't even know about it until it was too late.
And they sent us a paper last year saying they're going to put a lien on our property, and that's when we found out about it. Tell them that.
Yeah, we got a paper in the mail, I think last year, saying that they were going to try to take a lien out on property that I don't even own. And that was how we found out.
I have no idea, Your Honor. My presumption is that came from the Indiana attorney. But if you were aware at that point in time, you probably should have undertaken something rather than to waive that and be a stop from proceeding further.
Yeah, you have 21. First of all, Indiana says you were served by Deputy Sammy Bremer, B-R-E-M-E-R, on June 22nd, 2017. And he filed a document.
Okay, we didn't live there. We gave you a lease for a land contract house we purchased in 2017 before that date. And before that, we lived for a year in 2016 at 185 Station Street. This is a motion to set aside because we
He swore that he served you personally, handed it to you.
No, I don't think it says served personally, Your Honor. I think
no.
Oh, by their rule. Oh, yeah. Delivering copy of someone's dwelling house.
That's what this is about. We were never preside because we had no clue about it. We could never go to the trial.
Who's speaking?
I'm a witness to the matter that she lived with me.
You're not a lawyer. You're not a lawyer, and you can't represent Miss Mast. So if you just be quiet. Your ship sailed. You got served by Indiana Service in 2017. Whatever that service was good enough for Indiana. So the judgment is Indiana. We then registered the judgment here. And all this business about the car conked out and all that stuff
We're not properly served.
is not necessarily a defense. This is a loan to purchase the car.
In 2017, I hadn't lived in Michigan for years, so I don't understand how that's okay for them to serve papers to a home I didn't live in.
That's the bottom line.
Well, it was good enough for Indiana to enter the judgment. So if you want to move to set the judgment aside, you have to do it in Indiana. I don't have the authority to set aside the Indiana judgment. Now, let's assume they set it aside. In order to set aside a default